Give a minute for the rest of the attendees to be able to trickle in. It's starting to slow down just a bit. There'll be probably some joining us a little bit later on as we get going. Some are on their lunch hours here on the East Coast, so we'll wait. Just another 30 seconds or so. Okay, I think that looks good. We're going to go ahead and get started. My name is Travis Fincham. I am a Florida Bar Board Certified Elder Law Attorney here in Clearwater, and I helped start a pool trust called the Guardian Pool Trust about 22 years ago, and I still work for that trust today. And I'm going to have each of our panelists will introduce themselves as they do their initial talk. So I'm just going to give a little bit of overview, a little bit of background as to kind of how we got here. The elder law section of the Florida Bar has been following the events surrounding the Center for Special Needs Trust Administration's bankruptcy filings here in the Middle District of Florida on February 9th. A special committee has been established by the chair, Victoria Hewler, that's being led by Emma Hemnes, who's a former chair of the section. This panel is part of those efforts from that committee, and there'll be more forthcoming from the work from that committee as well. This program is going to be recorded. It will also be available to be rebroadcast on the Elder Law Section's YouTube channel. And Emily will be putting, for those of you that are here in Florida, into the chat, the CLE code for those, because we do have continuing education for the state of Florida. I would imagine most of you are familiar with the case. If you're not, you can view the case, again, regarding the bankruptcy filing of the center on the PACER program in the Middle District of Florida. So the Middle District of Florida's bankruptcy court. The case is cited at 8:24-BK 676. There are also numerous civil cases that have been filed in both the 6th Circuit and the 13th Circuit here in Florida. And there's also a federal class action case that was filed here in the Middle District of Florida. And the citation for that case is found at 8:24-CV 438, again on the PACER system. There will certainly be more civil cases. There may even be criminal cases that we brought, and we'll be monitoring those. And this is a quickly evolving matter. In fact, there are events that were happening as recently as Friday and today that we're going to find out a little bit about, including the possible appointment of a trustee, and we'll get to that in just a little bit. Today, we have national experts on this subject who happen to all be lawyers. We have 3 trust administrators, a national policy expert, and a bankruptcy expert. And then again, they'll each introduce themselves when we initially speak. So we have a lot to cover. I'm going to start off with David Goldfarb, who's in Washington, D.C., and he's going to give us some of the national perspectives and some of his thoughts on this matter after he introduces himself. So David, go ahead.
Well, thanks so much, Travis, and thanks to you and the Florida Elder Law Bar section for being really the first open panel to have this discussion. A little bit background of myself: I joined the Arc of the United States 2 years ago, and prior to that, I was the director of advocacy for the National Academy of Elder Law Attorneys, and so have been involved in special needs trust policy since 2014, including passage of the Special Needs Trust Fairness Act, which got individuals for D4A trusts, as well as recently with the Secure Act Section 401 carve-out exceptions. And so what I can say is the ARC National takes this issue extremely seriously, as do I think the entire pooled trust community and the entire elder law community. This is not just a Florida issue, and it's not just an issue for the states that are impacted. Everybody is taking a look at this. And in my view, the kind of the era of relationships are over, and we're entering potentially a more formal era when it comes to pooled trusts. A couple of key points before we move on to the things that we all want to hear about the state of it. One is that the creation of these trusts um, were by a hair, and Congress created them, and Congress can take them away. In 1993, as part of the attempt to get rid of the use of all trusts in Medicaid planning, the ARC was able to get narrow exceptions for D4A single first party trusts and D4C trusts. And in fact, the language wasn't so good because it was by faxes. And so, things like the Special Needs Trust Fairness Act had to been cleaned up decades later. And there was discussion, for example, about capping the amount of assets in it. I think importantly, what many recognize is that while SSA, CMS, and others care a lot about what the trust document says to make sure that it complies with the rules, whether it's an available asset or whether it results in a transfer penalty or whether distributions count as income or whether they can get access to the remainder in the case of Medicaid, the internal governance of these trusts are more or less unregulated. And there are a whole range of potential regulators outside of SSA and CMS that may have an interest here. That includes the IRS, state law, as well as we've seen recently in the past, even the SEC, although I'm not sure the state there. But needless to say, there is interest, and even local news is starting to ask that question. We'll be taking a close look at best practices as well internally, and I'm very glad that the industry is as well. So with that, I will now turn it back to Travis, and thank you guys very much. And I'll leave my email in the chat, so if anyone wants to contact me about national issues, I'm happy to listen.
Great. Thank you, David. And yeah, we have the ARC of the US basically to thank for the ability to have these. And the person that was instrumental in that was in David's chair back in '93. So David is now a policy person with the ARC. So we thank you, David. Appreciate that. Next, we're going to go out to the West Coast, and we're going to get Stephen Dale. And Steve advises a pool trust, but he's also the leader of a national coalition of pool trusts. And Steve's going to talk to us about kind of what that organization's doing, also his observations. I mean, those of us that work in this industry, we're all still kind of in shock trying to figure it out and trying to figure out what we do from here. So Steve, introduce yourself and then go right ahead.
Travis, thank you so much. And I know we're short of time, so I'm going to do my best just to focus on the Alliance of Pooled Trusts. I am a trust administrator with a non-profit called the North Bay Housing Coalition for the Golden State Pooled Trust. But I'm also speaking to you today as the president of the Alliance of Pooled Trusts. A couple of things before we get started. I know for myself, the whole center thing, bankruptcy thing, and I'm sure we're all feeling the same thing. It seemed like a horror story, here. And I don't want to, anything I say, I don't want to minimize anything about the breach of trust or harm to the families of the persons with disabilities, who of course should be our primary focus for this. Couple of things: not to paint the entire pooled trust community with the same brush. There are hundreds, and in fact, one of the problems is we have no idea how many pooled trusts there are across the country. To my knowledge, neither does Social Security, neither does CMS. Nobody knows that. But the vast majority of pooled trusts here are run by nonprofit community organizations that have oversights and that sort of thing. The problem has been, as David pointed out, this is an unregulated industry here that's been developing for years. And as I'm going to cover a little bit, those of us, who've helped form the Alliance of Pooled Trusts, and as I'll mention, it was not just pooled trust administrators, understand the vulnerability and the problems involved in this with these very precious funds that affect folks. It's not, sadly, it's not an isolated industry. The horrendousness of this is certainly unique, but there have been other breaches along the line, not only for pooled trust, but for individual trusts. And once again, part of, part of the recognition of the Alliance of Pooled Trusts is that these are very precious funds here, and that we do need to have standards and best practices. And not only that, measurables that not only families, but settlement planners and attorneys and all that can go through. So far, from what we can see, the measurement of a pooled trust seems to be whether or not they have a really nice website or not. And obviously, that should not be the measurement. Pooled trusts are an unregulated industry. Like it or not, we've all recognized that. And by the way, we recognize this. We've been working on this probably for a decade to meet exactly this kind of challenge. Obviously, a lot of this happened before we ever began with this here, but the need for meaningful, realistic standards, not only to prevent this type of thing, but also to have transparency here. One of the things really important is to look at who are the stakeholders when we look at pooled trust. And it's not just the pooled trust, it's not just the pooled trust administrators and all that. We all have a stake in it. So once again, it's wonderful that the ARC is so involved in this because, of course, in the end, it's the person with the disabilities and the families, but it's also the settlement planners, it's the attorneys, it's the investment advisors. It's all of this is to be able to come up with rational ways to be able to have that transparency, minimize the chance of a breach and that sort of thing along that line. Once again, as I mentioned, we have no idea how many pooled trusts there are. We have been working on this for some time here and all of that. Lastly, the good news is that as far as best practices, and once again, I know we're going to hear a lot about breaches, but a lot of work has been put into this. I'm going to do my best to post a link to where you can see the best practices that were developed between the Alliance of Pooled Trusts, Stetson, and by the way, another great organization, the National Plan Alliance, to really recognize the issue, the vulnerability, and the need for rational regulations and rational oversight here that will help these programs continue their important mission here. So for this, just in closing, because I know the most important thing that we all want to hear is to get a better understanding of what actually is going on. I want to invite, all of you are here because you have some interest in not only this case, but also ensuring that this sort of thing doesn't happen again and that we can move forward. The Alliance of Pooled Trust, once again, is meant to be a collaborative organization. In order for us to do the work we need to do, we can't just do it from the Alliance of Pooled Trust. We need the involvement of the ARC, and we need the involvement of NAILA and SNA and the Guardianship Association and the Settlement Planners Associations as well with that. So now, one of the questions did come up, and I want to address that is, what about insurance? What about bonds? What about, assessments and that kind of thing? This is something that the Alliance of Pooled Trusts has been looking at trying to put together and standardize. If you look at our activities with the Alliance of Pooled Trusts, it's all about education. It's all about the standards. We're doing classes on a regular basis to our members about what do these best practices mean, with the eye towards looking back at your own program to try to get as close. Remember, these are aspirational. I don't think a single organization could hit 100% of these aspirational standards, but we need those standards and we need to constantly be working towards that. So I want to invite folks as we work forward to try to minimize the chance of this thing coming up, to know that we are an inclusive organization and we need the input from all stakeholders here if we're going to make meaningful changes. With that, Travis, I'm going to pass this back to you, man.
Thank you, Steve. I know some of those things that you were talking about with best practices, and like you mentioned, insurance, you mentioned auditing, we've talked about that, having assets that are held away, kind of having independent investment advisors. I know something that David had talked about when we were discussing this as a group earlier was like the board oversight, the nonprofit itself, and how much information you can glean by seeing a 990, going through that. Obviously, you wouldn't catch some of these kinds of things that we're experiencing here in this case, but just doing your due diligence, just doing the background, like Steve's saying, kind of know who's involved, but ask those tough questions. Ask if they have an audit. Ask about insurance, and if so, how much do they have? Because just the ability to get insurance in this industry is pretty incredible. You have to have a pretty high threshold, a pretty high standard of practices, because the insurance companies want to come in and see what they're insuring. So they're going to ask those questions, and having an audit. And I know a lot of the trust that the ARC runs, get public funding, so they're getting audited. They're used to an audit, but these others that don't get public funding, if they're not doing a private audit or having it done themselves, they maybe don't have one. And so those are some of the things, Steve, I think that the Alliance is working on and trying to instill as best practices.
And part of this, if you look at our webpage once again, and you look at what are the goals, a lot of what you'll see is a recognition, and that has been up long before we were aware of the center breach, that once again, we need to be involved in legislation. We need to have some sort of, either if it's not an accreditation, a peer review or whatever. I mean, we might go through, there was an audit in this case, right? So it's not just merely having an audit or whatever, it's having an effective audit and that sort of thing. And there is no national standardization. It is kind of a hodgepodge. I would say, for those of you that watching, it's not as big a free-for-all as one might think. Here, once again, I urge you not to judge the entire community by this one incident, but we certainly need to look at it and learn from it, because part of it is, what are the measurables and that sort of thing. And I will mention, if the stakeholders involved in this are not just the pool trust administrators, it's I also work as an attorney. I need to have the confidence that if I make a referral to a pool trust, that that this is a responsible thing to do. If I'm a settlement planner, I need to look beyond the sale, quite frankly, here. So if I'm a settlement planner, I got a dog in this race. And I think that's something where we all need to pull together, and we need to work on making sure that we cannot totally eliminate theft, but we need to at least have those measurables and those things in sight, because this is, I can't imagine a more vulnerable population than what we're dealing with.
And Travis, just to jump in on the Form 990, a lot of the information you mentioned is available publicly. Form 990s are available publicly. They're about a year or two delayed, and all nonprofits and everyone in the nonprofit world looks at them, because if you're looking for new work, you want to know, well, how much is the CEO getting paid, and how much? And so there's a lot of information there, including, do they have an internal audit? Do they have any independent board members? There's information about their investments. So there's a lot of good things in there right now that can allow you to do your due diligence, to ask questions of those running it. And so I would just again urge everyone to, as we work towards these standards, right now you can look at a Form 990 and other information to get a lot that should help you do your due diligence. And ProPublica, if you search ProPublica Form 990, you'll find the database that provides them all. So that's a great place to start if you're not aware of that.
Thank you. Thanks, guys. So, so you've had the big picture stuff. The last two guys are kind of going to be on the hot seat to an extent. I mentioned before, we're all lawyers. I wanted to make it very, very clear that we are not giving legal advice here, but we wanted to get specific. We wanted to get down to what we know about this case, because a lot of it's public. I mean, again, you go right through Pacer, if you're willing to pay for those pages to download them, and some of them are pretty long, you can learn what all is going on, including that there is, I guess, a hearing going on right now as we speak. So we're going to try to give you some of the up-to-date things. Again, these guys are going to, I don't know if they're going to put their neck out of the line any at all, but we're asking for kind of some specifics. And then we're going to come back kind of as a group, maybe toward the end, and wrap it up and maybe ask each other some more questions too. So the next one is going to be Lance McKinney. Lance is a fellow board certified elder law attorney here in Florida, down in Fort Myers. He's going to talk about some of these best practices that Steve and David have already talked about, but also kind of maybe how they didn't quite get held up in this particular case, how they were, where the problems maybe arose from. So Lance, take it away.
Thank you, Travis. I don't fit in the national leaders of the rest of these panelists, as Travis indicated. I also, I'm a Florida practitioner, but we've been running a small local pooled trust for about 20 years. And I had the experience to end up suing the center because I had two clients in their being administered by them. And so trying to apply what were some of the red flags that came up and caused my clients to pursue a suit and recovery against the center. One of the, in context, although we've talked about pooled trust, the center and the bankruptcy cases that are involved here, it involved as many private D4A trusts as far as numbers of beneficiaries, probably as those beneficiaries affected in the pooled trust. And the lessons to be taken away or learned are not always so new here. It is the breaches of fiduciary duty. And so one of the red flags, which has not a flag of fiduciary so much, but my client, the family trust protector and guardian, actually was literally being attacked by the trust administrator, and they funded an effort to remove my client because they were asking questions. And so that was a troublesome person, frankly, from their point of view. That's my take on what their motivation was. But when we were interacting, I mean, literally, we were having to go get court orders from the guardianship court to force them to file trust accountings. And they were really behind on that. They were not providing them. They did ultimately provide accountings. And as they were doing that, then the paperwork didn't match up. And so so the lesson learned is you actually need to look at the accountings that are provided, certainly demand the accountings as they're required to provide. And you can see when discrepancies start to show up. One of the unique things in this case is that the Center for Special Needs Administration, they were using what I'll call pooled assets or pooled investment assets in the private D4A trusts. And so which really highlights one of the things, lessons learned or best practices is that these assets, one of the things you want to look for is to have them be held at a public custodian, something that is verifiable outside of whatever reported accounting being provided by the trustee. And so in one client's specific circumstance, they had $500,000 in a Fidelity account, and guess what? They were making good return on that, And then when you compared it to their proprietary pooled funds, they were making less than 1% over 10 years on those assets. And probably 80% of the trust holdings were in the proprietary non-performing assets. As practitioners, we know about pool trusts and some of these specialties, but a wrongdoer sometimes hides behind, the idea of, oh, what we're doing is so specialized that you don't understand it. And I got to tell you, as knowledgeable people, we understand that pool trusts, special needs trusts, it's still a fiduciary standard, and the standards of fiduciary behavior is no different. It may be different in the distribution standards, but the investing, all of that it's still the same ideas. So the takeaway lessons learned is get the accountings, look for substantiating paperwork. The center was preparing tax returns on behalf of this private D4A trust. And sometimes the tax returns showed individual fractional shares in real estate, but that wasn't on the accounting that they were producing. It showed it was the Center Realty Fund. So we had this kind of cloak, smoke and mirrors on how they were naming the assets. Of course, we asked for follow-up information, and that was not forthcoming. So takeaway is hold it in independent custodians, have it those assets to be independently verifiable, have the money be invested by an independent financial investor. Does the trustee have an IPS, investment policy statement that they can show that this is how they're approaching the investing? Independent boards and stuff are a great concept, but remember, these pooled trusts are often small disability groups, and they're often tightly knit. So I don't know that that's like the number one criteria. But as David and Steve were talking about, you can see how they're behaving. Are they using charitable donations to the trial lawyer bar, or are they actually benefiting disability groups or some other charitable group? And so when we looked into the center, the distributions that we saw in the beginning were not really going to a lot of disability groups. That's just kind of the flavor of who they are. It's not really a hot button maybe or best practice of fiduciary performance. Best practice, is there a two-person distribution system, so that one person can't just be in total control of the checkbook? These are natural questions that we should, would be in any accounting system. So I'm just trying to describe, as we were interacting, these were the things that gave us the red flags and caused us to take action. As I guess I'd close with, reputation. We depend and use peer reputation and referrals and stuff, and that's not the end. That's the beginning of the analysis. And then once you find someone that's worth looking into, asking these other independent questions is probably the takeaway. Travis?
Thanks, Lance. Yeah, appreciate it. Thank you for all of that. As you might have been able to gather, we've had 3 of our 4 speakers go, and we're only halfway through. So we kind of know who the star of the show is going to be, and that's intentional because, like Lance is saying, those of us that work in this area, we understand things like a breach of fiduciary duty and the duty to account, exploitation. I mean, we understand even some of that, and we see that in the criminal areas that we deal with. But what we don't see coming a lot is the SEC. Like I think Steve mentioned, we don't see the Securities and Exchange Commission digging into special needs trusts very often. Well, we just saw that. And then the other thing that we don't expect is how does this bankruptcy? When I first heard about it on Super Bowl Sunday, I think I got a text from somebody and said, "Hey, this has happened." And I said, Oh, well, probably they just got it over their head and their operating expenses and maybe their payroll. Never did I think that it was beneficiaries that would be listed as creditors. So just like any good lawyers do when they don't know, their subject matter, they go to a lawyer. And so the other law section reached out and found Scott, who is here in Tampa, and we're just trying to learn about this whole process because unless you've practiced, and some of our colleagues have practiced and dabbled some in the bankruptcy, it's a foreign process, and so we wanted to hear from Scott. It kind of, and what I also got from talking with Scott is he got it really fast. He picked up on what is this pooled trust, how to trust administration and all of this. And so he gets already kind of what we're doing and what we do for a living, a lot of us. And so I'm going to probably ask him some questions as we go, but I wanted to give him just an open floor to say, Scott, kind of what were your initial thoughts when you learned about this kind of a bankruptcy, and how is this one kind of different than most that you see? If you could do that after you tell us just kind of basically who you are, so everybody has your background. Scott.
Sure. Thanks, Travis, and appreciate the pressure lead up with that. Anyway, my name is Scott Underwood. I am a shareholder at Underwood Murray in Tampa. We are a bankruptcy boutique firm. We do all insolvency. Everything I deal with is distress, insolvency in some nature, even if it's not in federal bankruptcy court. I was previously at larger firms and was the chair of the Buchanan Ingersoll Rooney National Bankruptcy Practice. Travis, to your question, when I heard about this, I think I'd probably had a similar reaction, even without knowing this industry until this case. I've never encountered this industry of just sick to my stomach, right? Because we're in Florida, so fraud is not uncommon. Ponzi schemes are not terribly uncommon. Usually they come out when the economy goes poorly, right? A bad economy, the tide goes out and you see what's left on the beach. And a lot of times that's Ponzi schemes. And this one looks a lot like it. The difference here is most Ponzi schemes involve investors and sometimes often mom and pop people whose lives have been drastically impacted by that lack of investment. But not the circumstance you have here where someone got into the investment equivalent here, which is their trust fund money, by already being in a bad situation, or for many of them, victims in the first instance in this trust, especially because so much of these trust funds came in from lawyers. And so in a typical Chapter 11 bankruptcy, and I think most attorneys will probably be aware of this, but the idea behind Chapter 11 is that you're ideally going to restructure, or if you have a certain specific asset, it would be a sale scenario, but that the current management stays in place and tries to keep the business alive. And the courts are traditionally fairly debtor friendly in that they want to give the debtor a fresh start, give the debtor what's called the automatic stay, which gives the debtor a breathing spell from litigation, from various matters, with the real focus being, how do we revive and keep this debtor alive? Because as an ongoing company, a traditional ongoing company, you have employees and you have other suppliers and business and buyers, and keeping that commerce rolling is the goal, and why the United States was at the forefront of creating this type of bankruptcy law that's now been replicated. This case is almost the exact opposite, because while it was perhaps optimistic that the debtor in this instance thought it would be able to get through a Chapter 11 or file a Chapter 11 and continue in any way, and maybe an 11 was needed to operate the trust for some short period of time. But in this case, when you have a trust and you violate the trust, there's not going to be an ongoing business. Especially, this isn't we had to file because there was $100,000 mishap. This is obviously something far, far worse. And the other piece that flips upside down, and that even though there's a Chapter 11, you're not going to restructure, is the creditors are usually the secondary concern. In particular, the unsecured creditors, they don't have any liens on assets. Their interests are considered, but they're usually at the back of the line, and they're protected in a way, but they don't get to drive the ship, if you will. They're not the primary focus of a case. And here, the unsecured creditors are the entirety of the case. And you have a lot of very interesting dynamics, which I'm sure we'll get into, about the connection and the potential conflicts between the unsecured creditors, and that some parties here are not actually, some trust beneficiaries in this case may not currently be unsecured creditors, may not. They just happen to have their money still there if they were not, if there's somehow their account stayed clean, and what the debtor is calling clean accounts, which will be its own interesting element. And then I know, Travis, you have some specific questions, but one of the things I thought would be helpful is, before I go into the specifics, is just, there's a lot of players in this, and to walk through who the relevant players are and what their roles are within a bankruptcy case. Because there's, for instance, there's 3 different trustees. So the trustee, the first trustee that you're all aware of, essentially in this case, is the center. This is a trust. The center and the individuals running it are the trustee of the trust. Then once you file a Chapter 11 bankruptcy, initially the debtor is called a debtor in possession, meaning it's in possession of its own assets and operations. But there is a United States trustee. The United States trustee is part of the Department of Justice. It's a sub-element of Department of Justice to monitor Chapter 11 cases. And they're not really monitoring for criminal behavior necessarily, though they have the power to make criminal referrals, and the U.S. attorney will come in, and there are U.S. trustees who specialize in that area and will pay closer attention to certain matters, including this case. This case is getting attention beyond the Tampa level trial lawyer. So typical U.S. trustee, you get a trial lawyer appointed from the Department of Justice, and then you'll have maybe some oversight from the Tampa administrator. Here, this is certainly up at least to the regional office in Atlanta, and the regional head is monitoring this. Their role is almost a background referee. Essentially, in cases where unsecured creditors are not prevalent, or there are parties who are not represented, they defend, you can think of the process, because a bankruptcy case is very different than a piece of litigation where I maybe sue Travis's client, and we have plaintiff versus defendant. In this case is a good example, but in most Chapter 11 bankruptcy cases, you have dozens to thousands of parties with an interest in the case, and it's expensive for all of them to have lawyers and participate and protect themselves. So the U.S. trustee protects that process. The next, we talked about a debtor in possession. You have the third trustee, which is very relevant today and right before this meeting, before our webinar. A Chapter 11 trustee is a party that is appointed essentially to take over and to remove the debtor in possession from controlling and administering their own assets and running their own business. For a number of reasons, this was a case from the outset that appeared as though it was headed for a Chapter 11 trustee. Giving examples, the same bank that banked for both the center as well as the alleged wrongdoers, that bank was, and as of this moment, still is the banking institution for the center. There were individuals who were in management and on the board that were still in place that at least had some oversight historically over the last 10 to 15 years from when the bad acts occurred. Those things are unusual and they cause substantial risk. It was that debtor that had employed counsel to investigate these claims. That connection sort of, and the history here, begged for a potential neutral fiduciary to come in and gain control of this. The U.S. trustee that I mentioned just on Friday filed a motion, and the debtor consented to the appointment of a Chapter 11 trustee. The hearing on that was set on Sunday. Give you an idea how quickly bankruptcy courts move. That was set on Sunday. The hearing was this morning at 11 a.m. The debtor did not oppose. There will be a trustee appointed. The trustee, the order will be entered directing the appointment. Ultimately, the United States trustee will select the Chapter 11 trustee to appoint. It's possible that person changes, but they will select a Chapter 11 trustee. It's my understanding that the last constituency that I wanted to talk about, just before we get to the questions, interviewed potential candidates for Chapter 11 trustee, and that is the Official Committee of Unsecured Creditors. In a Chapter 11, unsecured creditors are, again, you may have small claims, so rather than having each creditor represent themselves, there's an official committee, and that is paid for from assets of the debtor. That is very complicated in this case as to what is an asset of the debtor, but the debtor in a bankruptcy has to pay for the legal fees and the accounting fees for the official committee of unsecured creditors. The members are volunteers, and their goal in that is to look out for the betterment of all the unsecured creditors as a pool. Again, that gets complicated in this case, but those individuals are very busy right now because they're trying to interview and locate their own counsel to represent that committee, but also now interviewing, and I understand even this morning, interviewing potential candidates for Chapter 11 trustee.
Wow. Okay, there's a lot you said there, Scott. We're going to unpack some of that and go in a little different direction on a few other things. So this is a Chapter 11, which is designed to be ongoing. The other kind is a Chapter 7, which is usually just a liquidation, my understanding, correct? You're liquidating and dispersing. So it makes sense for this to stay as a Chapter 11 because it's an ongoing business and it's so critical to the beneficiaries. Is that what I understand?
I think that does make sense. And as a matter of fact, the best thing the counsel for the debtors did was get it into a bankruptcy because it did need court oversight for moving forward. And it needed to have some method to continue operating because you have to manage these trusts. You have patients, or not patients, but beneficiaries who have needs, often as patients, to pay for their expenses. And someone has to manage that. And you have to ensure that still get those employees who are managing it get paid. And at least until you can transition these trust accounts to a new company, which it's not a given that's what's going to happen, but I think it's a likelihood, and a very strong likelihood, especially now that there is a Chapter 11 trustee. Having a process where you get court oversight and you have a court that, as I mentioned, will give you a hearing in less than 24 hours from the filing of a motion that's important is very helpful to that process, because the court and now the fiduciary Chapter 11 trustee can really get their hands around this and at least prevent further harm from here forward.
And I don't, we've heard from a couple of different sources, one pretty reliable, that the board members basically for the center have all resigned and the officers have resigned. I don't think that's in the public record or it's in the documents in the bankruptcy, but so what does that mean then? And I know David talked about, we have these nonprofits that serve as trustees. And so we have, in order to be a trustee of this kind of trust, you're supposed to be a nonprofit corporation. Well, if we can't just remove a nonprofit, can a trustee under the bankruptcy that's being appointed, they would then go in and basically become the center. They would take over the nonprofit at the center of the bankruptcy. Is that how that would work, rather than being a trustee in the general sense like we think of it over the trust itself?
Sure. So as a general rule, that when the Chapter 11 trustee comes in, even if the board had not, we've heard as well that on Friday, either right before or right after the motion to appoint the Chapter 11 trustee was filed, the board and at least some of the officers resigned. Functionally, when a Chapter 11 trustee comes in, it is a replacement of management. So the trustee is not the company. So to the extent the center was a nonprofit and the center itself qualified to be this form of trust, the replacement of management theoretically does not change that. If you were in a slightly different circumstance, like a nursing home, for instance, in a nursing home situation, you actually have to have a manager who themselves is licensed. And that can be a trickier appointment in a Chapter 11, or you need a very specific Chapter 11 trustee to be appointed who has that licensure. Here, as I understand, and mostly from my conversations with the other panelists here, is the center needs to qualify. The individual managers do not. And as we talk about moving forward and some criteria in different states, it's something that I wouldn't be surprised if it begins to get looked at. But so here, the Chapter 11 trustee's appointment would have functionally resulted in the termination of all of the board members and the officers. And so their exit at the same time that the debtor was consenting to appointment of a Chapter 11 trustee is, I don't mean this in a casting aspersions or not. It was a fait accompli. That's where this was going to end up. The more, in this case, again, because it's unique, typically a Chapter 11 trustee, their role is to shepherd the business. Oftentimes it is a sign that there's not going to be a reorganization. Sometimes there still will be, because you can sell a business as a going concern and it can move forward and you just need new management because of some other breach of trust. Here, that's probably not what we're having, but what you typically don't have is an involvement of an unsecured creditors committee. The Chapter 11 trustee, once you have that fiduciary, their role is to maximize assets, looking to be the fiduciary. So you don't need typically the creditor oversight of the debtor in possession that I described, who's managing. When the creditors are looking in and saying, is the debtor really doing what they should be, or is the debtor taking actions that benefit, say, the board? Maybe there's a sale where the board or the officers have a continuing role in the vice president of marketing of the new company. So they really want that to be the solution when there's better solutions. And that's the primary analysis is an economic one of, are the current management acting in everyone's best interest for their own, or are they looking at situations too narrowly? Do they, are they committing fraud post bankruptcy? Are they losing money? So when you have a Chapter 11 trustee, that role is already moved over to someone else.
Okay, because we talked about the the role of the creditors committee, and so that kind of does change then with the appointment of trustees. Yes. There will still be a creditors committee, or maybe not. Do we know?
So, as I understand, the U.S. trustee still wants a creditors committee to be somewhat active. I think in this case, even though it may not be traditional, that makes a great deal of sense, because the unsecured creditors here are very unique, and some of them will have essentially trust funds being held still, even if they might be a partial unsecured creditors. So there's really a unique interest of these unsecured creditors compared to your typical economic parties. The typical creditor on a committee is a supplier. If you imagine a clothing company, it's the denim supplier, and they may have an interest in getting paid for the denim they provided already, but they also have an interest, if the business survives, in selling denim again. All these economic interests are so different here, right? The interest is maximize the recovery for those who have lost money and protect the further loss of any money from those that are in the trust or that are still in the trust and have funds. I mean, just as an example, the debtor filed and indicated on schedules it had approximately $4 million in cash that claims as its own asset. And that is generated presumably from fees on the trust that even an ordinary well-run trust is an appropriate fee to provide the service. It costs money, that's how it operates. But here with $100 million stolen 15 years ago and covering that up for many years, they presumably, those individuals, to part of the cover up, if you wanted to tell people your money was still here, you have to charge them a fee. Well, who's paying the fee for the empty accounts? Either it's not getting charged and the center's overinflating its income and not charging that and just reporting it, or the fees being paid from other members, other beneficiaries. I don't know that. I want to be clear. I don't have an insight into that level of accounting, but the debtor has filed and said, look, everyone falls into these various buckets. You have essentially empty accounts, compromised accounts, or what they're referring to as the clean accounts. I am at least have questions, and I don't represent anyone yet in this case. I think I've shared with others that we've received a lot of calls, but don't have a stake in this yet. But how you even have a clean account in this circumstance, which was largely being run like a Ponzi scheme to continue covering losses and hide the fact that money was missing for such a long period of time, based on other Ponzi's I've seen or other circumstances like this, is difficult to understand how that could possibly be.
And just to put those, for those of you who aren't familiar with the numbers, the first 50 million was in 2009, and then the second one was in 2012. So that's been 12 years ago that there's been there's 100 million less than they could account for, even though they were still carrying it on the books. And so, yeah, so how are they charging fees? I did a quick calculation based upon the number of beneficiaries that they say they have and the amount of money that's there. And that would have been, their fees last year would have been about 5.1% of what they said they charged last year of a $100 million trust. Well, if they were counting it at 2 million, then it's kind of 200 million, then it's half that. So we got 10 minutes, a little more here. Big question, Scott, is so because it's an unusual type of bankruptcy. Creditors are kind of in the debtor's role here, and debtors are in the creditor's type role. What are the options for these beneficiaries? Again, without giving, we're not giving specific advice to particular beneficiaries, but what typically are their options?
So there's a number of options in this case, and I'll kind of walk through some of them and some of the at least considerations. Again, not providing any legal advice. The most simple is it's a bankruptcy. If you think you have a claim and you wish to participate in the claims process in the bankruptcy, you need to fill out a proof of claim. It's a fairly straightforward document. It is one that you do not need to be a bankruptcy attorney for. So you don't need to be admitted to the bar. That's probably important for a lot of your members that are attending here. You can submit a claim, even just a company can fill it out themselves, an individual, their beneficiaries. You don't even need an attorney to do it. You can mail it in, you can do it electronically. The consideration when filling out a proof of claim is when you fill out a proof of claim, you have submitted yourself to the jurisdiction of the bankruptcy court. That may become relevant depending on the other options. So let's move on to another option. A simple one is, can I move my money that's in trust to another account, to another trust? That would traditionally be a fairly straightforward question. If you had a clean trust and you knew your money was in trust, your money in trust is not property of the bankruptcy estate. Now, if you have a contract to keep your property, to keep your money in trust with the center, as opposed to just a grant of you are my trustee and I can change this anytime. You actually have a contract, say, for a year that renews. The contract itself is property of the bankruptcy estate. This is relevant for whether you need stay relief or not. As a practical matter, you have to wonder whether a Chapter 11 trustee or anyone would be going after individual beneficiaries who move their money to another trust. But here that is very complicated because we don't know the reliability yet of the accounting. And until a Chapter 11 trustee gets appointed, gets their own forensic accountant in to really get their hands around this, I don't know how anyone's going to be able to say, yes, you can withdraw your money because we know this is exactly yours. Unless there is an account that's separate for, certainly the pooled funds are going to be very difficult. But if you have an individual account and it has pristine records that you can actually confirm with a bank, that's an option. Other options, you may be able to bring lawsuits against individuals to the extent you have direct claims. Direct claims versus derivative claims will be something that moving forward, no matter what your role in this case, will become important and may drive your decision making. The money in trust being lost, if you can locate the person who took it, you may have a direct claim. You may have a direct claim against, and to the concern of some on this, against the lawyer who referred you, or the settlement planners who referred you to the trust. That the questions would be, what type of relationship did you have with them? What due diligence did you do? Did you ask whether they had insurance? Did you ask if they get an annual accounting? Or was this just a company that maybe you knew had a good reputation? That would be positive. Worse end, and I don't know if this exists, but worse end would be you find out that in fact, you had a situation with similar to Insys and some of the fentanyl drugs where you had huge fees being paid, or someone was a frequent guest speaker. There was some type of benefit being provided to the referring party. That will be an issue. There are potential claims against, I mentioned the bank that was on both sides. There have been claims, I'm not asserting those, but there have been claims asserted against the bank in the class action case. They're in traditional Ponzi schemes. Often the claims are raised against the bank that they should have known their customer more. And when accounts are denoted a trust account, that they have some arguable direct duties. Then you have, and there can be others, right, that are insurers, certainly the bad actors. If you have a direct claim against a party because they directly harmed you and owed you a duty, you may be able to bring that either alone, or maybe you join in the class action to the extent the class action moves forward. The other alternative is, and this is where the bankruptcy piece comes in, you cannot sue the debtor right now. There's an automatic stay from suing the debtor. It's also probably not much point to suing the debtor, because what the debtor is going to do is ultimately be bringing claims that it can bring against anyone who's many of the same parties I just mentioned. as well as potential bad actors. If the debtor had a director and officer liability policy, and this is not an excluded item from coverage or errors and omissions, depending on what type of policies, there are claims where the debtor itself was harmed by the bad acts. The fact that someone steals $100 million utilizing the debtor as a mechanism means the debtor itself has a claim. Individual beneficiaries who have lost funds cannot bring a derivative claim that is essentially a claim that belongs to the debtor, because that is an asset that belongs to this debtor, and it is an asset that will now be controlled by the Chapter 11 trustee. So ultimately, what does that mean? How does that play out? How do all these moving pieces, all these various competing claims against functionally the same parties, whether you have a direct claim or it's derivative, the targets, whether they're rightful targets or they properly defend themselves, the insurance companies, they're all going to be the same targets. What hopefully will happen is there will be some cooperation. And this is where, again, having myopically, those of us in my world think we're helpful rather than not. Others may have different perspective. You know, if you're the individual lawyer who wants to bring a case and you're being held up for your client to sue a specific bad actor or specific accounting firm, you may view this as a real problem. But in the bankruptcy court is going to look at this as a collective and try and get their hands around the entire situation and say, we need a fair process. And hopefully there will be some coordination between the eventual Chapter 11 trustee and the claims he has with individuals, so that this is an organized process and you don't have 15 different lawsuits against some of these companies. And then the last wing, and I'll try to be quick because I know we're almost getting to the end, we don't yet have a governmental law enforcement process yet. And you might have that as well going after specific assets through the forfeiture process. And hopefully those processes will collect the maximum amount of assets and come up with some fair process of distributing.
And so, yeah, that was kind of my last question. And then we're going to go over by just a little bit, just so everybody knows if you got to drop, you got to drop. But we're going to keep this for just at least another 5 or 10. But so when you say other, are you talking about criminal? Is that criminal cases you're talking about? We know there's not been any criminal indictments that we're aware of or any of the other, yeah. But in situations like this, if a criminal investigation starts, what does that do? So we talked about that. What does that do to the bankruptcy itself? And if that were to happen, what would we expect? So,
yes, I'm not aware of any current charges. It can be an SEC process. There are other administrative processes, but traditionally we're talking a criminal proceeding, maybe federal, maybe at the state level, but a criminal proceeding. And what you end up with is, again, we have a bankruptcy judge in Tampa, Judge McEwen, that refers to it as the race to the race, right? RACE to RES, right? The race to the property. The criminal side is one more aspect. Now you have a different governmental agency that is going and attempting to collect assets, ultimately for purposes of making restitution payments. Where it can get messy is figuring out how the government, the law enforcement side, which is very good at getting assets, it can be very helpful to the process because their forfeiture powers are very, very strong compared to a civil actor, which a bankruptcy trustee, Chapter 11 trustee is still a civil actor. But their distribution process traditionally has not always been as smooth. That's not what law enforcement does. They do that some, but that's not what they do all day, every day. So in a case that some of us would know about, the Rothstein-Rosenfeld-Adler case, that's exactly what you had. There was a lot of forfeited assets early on. We know Scott Rothstein loved his vehicles, cars, boats, etc. And there was tens, if not hundreds of millions of dollars get seized very early on between property and vehicles. But then how do you distribute that? How do you liquidate it, have a fair process? Ultimately, there was generally more to the detriment of victims there. There was more litigation over that, which takes away money, which goes to my point of hopefully there will be some cooperative process earlier here. In the end, who administered those assets after they were seized went up in, I think, to the 11th Circuit and finally came back and said, look, government get the assets. Why don't we let the bankruptcy court and bankruptcy process distribute? Because that's what this court exists to do, is have a fair distribution method. And fairness is very complicated in this, as you might imagine. There will be a lot of tracing analysis. There will be a number of forensic accountants for different parties that try to untangle what happened. And the fact that this happened so long ago and then has been slowly being covered up over the years is not going to make this an easy forensic process. Forensic process is really difficult if you're looking back 2-3 years. Here, it's such a lengthy period. What even at the records? We don't really know what quality records we're going to have here. Now, maybe people may know. When I say we, I mean the public that isn't having access yet.
I'm going to open it back up. I know, Steve, I think you had a question, but I'm going to open it back up to the panel. Yeah.
I just had a quick follow-up question for you, Scott. I understand that accessing the funds that are there is going to be a problem. But what if I had a case, and I have an attorney here who has 12 of these, where there's a structure involved, a structured settlement annuity. So you've got a stream of income, and then you've got the corpus of the trust. I understand the corpus of the trust is probably, hands off. But can I just toddle off to my state court and say, stop directing that income to the center, direct it to a new trust that I created for that stream of income?
So, yeah, I think I understand the question, Stephen. The stream of income, the income itself, is not property of the estate. So acting over control of that property is not itself, theoretically, again, I'm not giving legal advice that each case may be different. Assuming you've not pre-assigned it, it's not property of the estate. That all changes if, in fact, you have a contract. If part of the trust taking over is you have committed to funding this under some written document, then that document and that contract right, even one right under a contract, is property of the bankruptcy estate. Now, would you have cause? Does that mean you're out of luck? No, you may be able, and I think you would be able, to get relief from the automatic stay, perhaps even on an emergency basis, so that you could redirect your funds, and that moving forward, you would have a process to do so. As a matter of fact, one of the things we haven't talked about here, but I wouldn't be surprised now that you have a Chapter 11 trustee, and even the Unsecured Creditors Committee that I mentioned, it's brand new. They don't have counsel yet. Even though this case is a month old, I don't know the backstory on why the committee was just created now. It's a little surprising to me from not being involved in that process why it was. Maybe people were vetting whether they wanted to volunteer or not. But now that you have the committee in place and you're going to have a trustee who's not going to be as focused on moving the business forward, I would not be surprised if you start seeing proposed procedures and orders and proposed documents that is a process to allow the reassignment of proceeds that have not gone into the trust to start going somewhere else without everyone having to file stay relief motions, because I don't think the court nor anyone else wants 100 motions for stay relief. So I wouldn't be surprised. I don't know if this is happening, but I wouldn't be surprised if there is a protocol set up in the fairly near future, now that management of the old debtor is displaced and the focus on how do we maybe keep this thing operating is probably going to the wayside, as opposed to how we treat people properly moving forward. And I'm not saying they weren't concerned about treating people properly with the professionals that were in place in the bankruptcy, but there's different duties and different mindset. And so if you filed a motion for stay relief because you think you have a contractor to get your money out and you filed it, cause is the standard, and that can be almost anything. Usually it's an economic standard. Here, cause is fairly self-evident. This is a trust that cannot be trusted, and there probably is very little more to say to get stay relief.
Great point, great question. Any of our other panelists have any other great questions? We're over by a few minutes, but we were told they wouldn't kick us off if we went over by a few. Does anybody else have anything else to add? If not, then thank you to the panelists on such short notice and getting this together and stepping up and volunteering to do this. We appreciate your time and effort you put into it. Those of you that attended as well. Again, there's the course number for this, for those of you here in Florida for continuing education, is 8380. And this will be recorded. It will be on the Elder Law Section's YouTube page. So if there's someone who wants to go back and mull it over again and hear it all again, you can go back there and listen to it as often as you like. And the Elder Law Section in Florida is committed to continue to follow this and to try to figure out what we can do to help those that are impacted. Again, these beneficiaries are foremost on our thoughts and in our minds. We're trying to figure out, and this was our first of hopefully many other efforts to try to figure out how we can help them. So having said that, thank you all. Have a good rest of your Monday and rest of the week. Appreciate your input. Thank you.
Thank you all.